Well, good morning. Thank you, committee members, for today's hearing on Senate Joint Resolution 82, which amends our state constitution so that judges can consider a multitude of factors when setting bail. While preparing for today's hearing, I went back and read my testimony for 2017 Assembly Joint Resolution 93. Yes, you did hear that correctly, 2017. Representative Duchow and I first proposed this change 5 years ago. I then reviewed the materials from the 2018 Legislative Council Study Committee on Bail and Pretrial Release, of which I chaired, and Representative Duchow was a member. I make a point of mentioning this because this is not something that is a knee-jerk reaction to a specific incident. Many people may think this proposal is because of the Waukesha parade tragedy or the attempted murder of the off-duty law enforcement officer last week in Milwaukee. While low bail was clearly a factor in those incidents, they were not and are not the reason for SJR 82. Fact is, Wisconsin's bail system has been in need of change for a long time. Most people are shocked to learn that under Article 1, Section 8, Clause 2 of Wisconsin's Constitution, a bail amount referred to as a, quote, monetary condition of release, unquote, may only be the amount that ensures a defendant appears for trial. Under Wisconsin's Constitution, the seriousness of the offense, the potential danger of public safety, and criminal history is not permitted to be considered when setting monetary bail. If a person has roots in the community, a job, a family, a home, etc., they are more likely to be released on a low cash bail or frequently just their word. For years, we've seen the detrimental impacts of this law. You don't have to go far to find the impact. You can look at last week and the shooting of the police officer. You can look at last year when the 6 people killed in Waukesha at the parade. You can see it in the Fox 6 report on December 19th, 2021, which found that of the 117 people charged with homicide in Milwaukee County last year, 25 of them were out on bail that ranged from a high of $10,000 down to $0 signature bond. That's just Milwaukee County. If people looked at other counties, you would likely see similar issues. Based on feedback from legislators and interested parties, we have offered Senate Substitute Amendment 1, which you should have received this morning. And this amendment focuses on Clause 2 of Article 1, Section 8. It gives judges broader discretion in setting conditions of release and requires judges to set bail or a monetary condition, quote unquote, based on a number of factors. As well, undoubtedly here today, bail is a legally and constitutionally complicated subject. Therefore, changes should be carefully considered and evaluated. After 5 years, this proposal has been through the ringer, and in my opinion, threads the needle between protecting the public and victims and preserving the presumption of release prior to conviction. Senate Joint Resolution 82 and the public we serve to protect deserve your support on this bill. And I turn it over to my colleague, Representative Duchow.
Thank you, Senator Weingart, and thank you, Senators, for hearing this bill today. You have my testimony in front of you, and Senator Weingart did an excellent job in summing this up. So I'm not going to read it to you, and I know that everyone's got a busy day ahead of them. The impetus for this bill was a gentleman on my street molested his 3 grandchildren. And because he was a member of the community, belonged to the local church, had lived there for actually second generation to live in that family home, he was let out on $75,000 bail. And I have a neighborhood full of kids. The bus stop was actually at the end of his driveway. And he was out because they were working a plea agreement, basically living a free life, sitting out at his burn pile at the end of the night and being able to go to the grocery store and go to church. I reached out to the Waukesha County DA and they explained to me, bail is really set to make sure you return to court. And because this gentleman had such ties to the community and took out a second mortgage on his house to make his bail, he was not going to leave his wife high and dry. They felt that he was no flight risk at all. But it was certainly disturbing to the rest of us in the community. And for someone to get 3 months out to live their life while 3 grandchildren were molested just didn't seem right to me. And when I talked to the ADA, he felt very strongly that we needed to change the Constitution to fix this problem. And we worked with Brad Schimmel on this, the last AG. And so we got this through the assembly once, and somehow it stalled, and there were some concerns about people's civil liberties, and that is why we added in there that they had to look at your past criminal convictions, not just your past criminal charges. We thought that would alleviate any concerns as someone's being held, an innocent person being held in jail. So with that, we're happy to take any questions.